So thank you for joining us this evening. This is the program that the League of Women Voters of Detroit and the Detroit Public Library have been running on Zoom since September of 2020. We have kept it on Zoom because that has been a lot more convenient for most of the people attending. We do supposedly have the option now to also show it in the Napa branch of the Detroit Public Library, which is where I'm stationed right now. Please, you were brought in with your camera and microphone off. If you have questions, please put them in the chat, and Ruth Colwyn, one of our committee, will capture them and make sure that they're asked at the end of the presentation. Our presenter tonight is Joe Gavin, and I can't read my screen. He's the current president of Michigan Supreme Court Historical Society. He is an attorney with the law firm Miller Johnson in Grand Rapids. He is a member of the firm and practices in healthcare litigation. A former pre-hearing attorney with the Michigan Court of Appeals, Mr. Gavin has been practicing law since 2006. Thank you for joining us, and Mr. Dr. Gavin, Mr. Gavin, sorry.
Mr.
Yes. Well, no, I'm still just running in several directions at once, which never works. Thank you.
I'll take Dr. Jen. That's actually
all right. You've got a doctorate now.
That
Congratulations.
Works. Technically, it's technically I did get my Juris Doctor, which is what the law degree is. But even Joe is really fine. So, thank you, Jennifer. I appreciate the opportunity to sit here and speak to you all this evening on a topic that I think is hopefully relevant to today, even though it's concerning the history of our state and the history of its court in some respects. As Jennifer said, I'm the current president of the Michigan Supreme Court Historical Society. The essential mission of our society, if I can just plug it briefly, is to preserve and disseminate the history of Michigan, the Michigan Supreme Court, and Michigan courts more generally, with a view towards increasing awareness and supporting engagement and just making sure that the citizens of our state know what that institution does and what it has done historically. My hope here tonight is to speak on some of the earlier decisions of the court, how those decisions intersected with civil rights issues over roughly the first century of the court's existence. So as I said, thank you all. It's fine with me if there is some interaction, as I'm obviously going to try to preserve time at the end for questions. I know we have till about 6:30. I will definitely keep some time at the end of my presentation for questions. If you have an absolutely burning question, feel free to put it in the chat, and I'll see if I notice it. I'll try to address it in real time. Just a quick note before we get going. Just a level set for everyone. I'm sure that the folks I'm speaking to probably know all this already, but I think it's just worth a level set for us all so we can kind of have a good understanding of terms. Obviously, our Michigan state government kind of mirrors our federal government insofar as it has, three branches of government. So it's the legislative, executive, and the judicial. In the legal world in law school, and even as we teach our kids in elementary school, I mean, the three jobs are essentially to make, enforce, and interpret. So legislature makes, the executive enforces, and the courts interpret the laws. And so essentially that's the job of the courts, and the job of the Supreme Court throughout its history has been to decide disputes between people as they exist under the law, and for the court to, in that process, to say what the law is. That's not always easy, as we'll see. Sometimes the meaning of the law is less than clear. And so there's a process that the court engages in to fill what one former justice of the court called the interstitial gaps that exist in the law. They're basically like, think of a brick wall that has a fairly well-built structure, but there's missing bricks here and there. And that's kind of what the job of the court is to slowly, incrementally, over time, fill those bricks. And it does so by issuing what are called opinions. And we're going to be talking about a number of those opinions tonight. It's essentially when there's a majority of the court to decide a particular issue that becomes the opinion of the court, which then becomes something that kind of becomes its own law, even though it's not technically law that was created by our legislature. And so, just a word also in terms of terms, we're talking about decisions that were issued, a long time ago, as early back as the early 19th century. Some of the language that's used may be, in some respects, difficult in our ears. Some of the ways in which the court discussed issues surrounding, in particular, civil rights and the disputes that would come between blacks and whites. The language that the court can use sometimes can feel very tinny to our ear. So I'd ask you to just give a note of grace as we go through this, because sometimes the language that was used in those opinions, it feels, as you'll see, challenging to digest to a modern ear. But the real question, I think, as people that are lovers of history, that are interested in history, is what can we draw from those earlier decisions? What can we learn about our state and the court as an institution, both good and bad? Because as we'll see tonight, there's hopefully what you'll get from this is that there's not a clear, this institution is absolutely good or this institution was absolutely bad. It's much more nuanced than that. The only thing I'd say is, as Jennifer mentioned at the outset, I'm not a historian. I'm a lover of history, but I am a lawyer by training. Now, those two ideas, law and history, can and do often overlap. The law itself is in some ways a conservative profession. And I don't mean conservative, politically conservative. You've got folks that are politically liberal and politically conservative and anywhere in between. What I mean to say is that the law by its nature is an institution that seeks to conserve and rely on the existing structures of society. And courts, by their nature, look to past precedent. And they look to establish legal customs for guidance. Judges are reluctant sometimes to go out too far on a limb, and so they look for what other the courts have said, how other decisions have been handled. And that by its nature means it tends to be one that conserves the status quo, as we'll see in some of our discussion. But the law does look to history. And so I think it's important to start off our discussion with a word of history. Just more generally, to think of Michigan legal history. And when I think of it, in terms of my framework, I think of the history of law as a history of a people and its place. And that's really no less true of the court system, as we'll see. The court system kind of reflects, it's almost a mirror of a people and its place as regards its history. Now, geography obviously matters a great deal in that. In Michigan, in its early history, it mattered in particular. Detroit itself stood at kind of a crossroads of waterways. And so that was a natural place where people began to emigrate. Now, early in its history, and we're talking in the 18th and early 19th century, so around the time of the American Revolution, as people began to migrate to Michigan in more significant numbers, the population of that period was drawn substantially from the greater New England area and New York in particular. Because you'll look on a map, you'll see how the geography kind of naturally lends. As people move west through New York, they naturally can find themselves headed to Michigan. And so what happened was the legal code that was adopted in the nascent Michigan, before it became a state, and even after statehood, it adopted much of the code and the laws from those New England territories as part of its legal system and its constitutions. As I said, the law generally reaches backward and it relies on precedent. So just a brief word also about what the idea of the common law is. As I said at the beginning, we have our three branches of government, and the legislature makes laws and the courts interpret them. But I'm going to give a slight exception to that because in the history of England, if you go back far enough, the English tradition included this concept of the common law. And it was essentially this idea that as judges were called upon to decide cases, they would use, I guess the best way to say it is, their basic sense of justice and fairness and the structures of the legal system as it existed, and they would lace all those things together and deal with new problems as they arose to that basic sense of their legal training and justice and fairness. And that process, that iterative process, slowly, incrementally would change the law. And it would change it through this concept of precedent and what became the common law. It was the slow development of new case after new case after new case that changed the law. And that system, that common law, actually got imported to the New England states when the colonists came, and then it made its way into Michigan. And so that the cases we're talking about are the slow, continual, iterative process of how the common law would in part shape the legal landscape of Michigan. So there's the theoretical idea that legislature makes laws and courts decide cases, but that starts to break down even at the very beginning because cases get decided by courts, and those cases become their own precedent, and really they become, in some respects, their own law. But those traditions get inherited through the common law, and in a sense, each generation that succeeds is sort of looking backwards to what the previous generation did, and it helps inform how they resolve their own disputes today. Lawyers who are practitioners still do that. We routinely look to decisions that were decided 10, 20, 50, even 100 or more years ago for guidance in how we understand our cases today. I had a case a few years ago, not to digress, but I was researching law that went back to Roman days to understand essentially the history and how that would develop. And so you really can't have a complete understanding, in my opinion, of the history of law without getting your arms around where that law came from. And Michigan drew much of its tradition from New England, which drew out of the English common law. And so what ultimately happened, though, because we had the migration of peoples from the New England area into Michigan early on, what that meant was you had almost a puritanical strain. People from New York and New England emigrated here due to the proximity, and they brought this Puritan heritage with them. So early on, even Michigan had what we would almost characterize as modern senses of progressivism. There was an early abolitionist ideology that was brought into the territory of Michigan. And we say progressive, it's progressive for their day. So as a simple example, Michigan had a very, very early opposition to the death penalty. That was considered, under at least that ideology at the time, inappropriate. And Michigan was actually the first jurisdiction in the English-speaking world to formally abolish the death penalty. We never had it. So I say that not because it directly bears on civil rights cases, which is the topic tonight, but it gives you a sense as to some of the early views that the people that emigrated here had. So this stands actually in contrast to other areas of the country, even ones that are close by. And so Michigan would be in contrast to, say, for example, Ohio, Indiana, Illinois, where the population migration was more comprised of people emigrating from the South. And so you saw in those jurisdictions early adoption of repressive codes when it came to Black citizens who were there. They adopted and enforced them, which actually stands in contrast to what Michigan did early in its day. We'll see that's a little more nuanced than that, but there was that contrast, which actually started to, as we'll see, encourage and help develop a reputation of Michigan's reputation as sort of in some ways, a bastion of freedom within the early American experiment. So let me go ahead and share my screen. That's bringing us pretty much where we need to be here. I can share a PowerPoint. All right, I think I'm doing this right. Jennifer, or can someone confirm for me? You all can see my PowerPoint here?
Yes.
Wonderful. Okay, great. So let me just skip here. I guess I didn't really need that slide since we're talking, but I'll go on. I kind of wanted to then bring folks up to speed also on really Michigan's journey from territory to statehood. So if you think about it, I mean, the earliest European settlers here, came here as fur traders, essentially, or in some cases, they were folks who were looking to evangelize Native Americans who were living here. But eventually, enough population moved here that Michigan, before it became a state, became a territory. So a bit of background. Uh, Everybody's, I'm sure, heard of the Continental Congress. This was, the authority in the original 13 colonies that did a number of things that included adopting the Northwest Ordinance. And what that really did was it tried to establish an American government for the territory of the United States northwest of the Ohio River. And the idea was, as you started to see migration into the Michigan area and Ohio and other areas within this Midwest, what we now call the Midwest, they needed some basic structure of government to resolve disputes, to understand what the legal landscape was. And so the theory was that as people continued to migrate, the areas could transition to statehood, but it began in Michigan. In part, began as a territory. So this American government was set up, and it was governed by three individuals. Actually, I'm sorry, three branches and five individuals. So there was a governor, secretary, and three judges. And they were all appointed by the Congress. And so you had folks that weren't necessarily well connected with Michigan, but that was the essential structure. And then these governor and these judges also acted as essentially a legislature for the Northwest Territory, which included the territory of Michigan. So, excuse me. Once a particular district or area had 5,000 free adult male inhabitants, notice my qualifying language there, free adult male, those legislative duties could then be transferred to an assembly, something similar to our own legislature today. And then once a district had 60,000, again, free adult male, notice my qualifications there, inhabitants, it could become a state. Now, one of the keys here to this was that the Articles of Compact that existed in this creation by the Continental Congress, and this was an article between the original 13 colonies / states, and any new entrance was that as states were added, all basic guarantees that had existed would be provided to new entrants. And so the idea was that you would create this equal footing in a sense. It's that way it helped ensure that each new state that came in was not sort of a second-class state in relation to the original 13 colonies. So those legal systems that it guaranteed included things like religious freedom, included things like due process, which is essentially legal speak for ensuring that we don't just throw you in jail, but we have a process to ensure that you're duly convicted of a crime if you're put in jail. Things like just compensation for eminent domain. If the state determines it has to take your property, which sometimes happen, that you get just compensation for it. There are bans on things like cruel and unusual punishment, all of which make it into the United States Constitution. Those guarantees are put in place for the territories and the states as they expand. Now, this original territory, the Northwest Territory, was vast. It comprised of Michigan, Ohio, Indiana, Illinois, Wisconsin, and even parts of Minnesota. It was originally controlled by the French and then later the British. And the governor and the judges were actually based in Ohio, in Cincinnati or Chillicothe, Ohio, which is essentially 240 miles away from Detroit. Now, it's a long drive today, so you can imagine what it was like trying to travel there one way or the other to have legal disputes resolved or things of that nature. Now, the Northwest Territorial Court actually traveled to Michigan only twice in 6 years. No territorial governor ever made it to Detroit. This obviously presented hardships. And so when Congress created Ohio, it excluded Detroit, Mackinac, and Sault Ste. Marie from that, and it made them subject to the Indiana Territory. And with its capital was in Vincennes, Indiana, which was now 411 miles away, so even farther for the Michigan residents to travel. And I think at that point, the residents of Michigan had had enough, and they petitioned Congress for a new territory. This was on January 11th, 1805. Congress created the new Michigan territory. Now, what happened was when they did that, they created a government that was in all respects similar to that provided by the Northwest Ordinance. So it had all those protections that we talked about. And Thomas Jefferson, President Jefferson, actually appointed the original individuals who sat on the government of the Michigan Territory. General William Hull, somebody Jefferson knew well, who actually fought with him had been part of the Revolutionary War. He was governor. Stanley Griswold, New Hampshire, was secretary, and there was a 3-judge court. A gentleman named Samuel Huntington, who actually declined the appointment. Augustus Woodward, I'm sure many of you will note that name, Woodward. It's obviously continues to be an important name in Detroit. And then Frederick Bates, who was the only Michigan resident actually appointed to the court or any position of authority later on, they were joined, because Huntington declined, they were joined by John Griffin, who had said wanted to leave from day one. So not exactly an excited government for the new territory. These folks were kind of political appointees by Jefferson to bestow patronage and to ensure loyalty to the existing American Union. And so because you had French and British residents in the Michigan Territory, they were suspicious. The American government was suspicious of appointing people who may have had a different allegiance. So that was part of the motivation. But the whole idea was to essentially continue to exert some control over the territory by the American government. Now that structure, that territorial structure, continued until Michigan achieved statehood in 1837. So when we start our discussion tonight, and let me go ahead and just get forward here, we're going to start some early cases from the territory, and that's really some of the earliest decisions of that territory are really quite significant, as we'll see. I think I may have seen a question come up in the chat, so let me see if I can stop sharing briefly.
It was just me
was it? Okay.
telling folks that they could put questions there. Yeah.
Okay,
Sorry.
great. Oh, no, quite all right. So the way I've divided the presentation tonight is with that sort of background. My goal is to talk about a handful of subjects that really were critical to some of the early decisions of the court in dealing with civil rights issues, in particular for Black citizens of the Michigan Territory and ultimately the state. And so we're starting off with the most obvious topic during the day, which was issues surrounding slavery. We're talking about a time period that was before the Civil War, so slavery was alive and well in the southern United States. And actually, even though Michigan never had the formal institution of slavery, there were, as we'll see, some incidents of it occurring within the jurisdiction, the territory of Michigan. And so we'll start with actually one of these early cases. And actually, before I get there, I should say a brief word about the court, because this is an important point. We have a certain vision that in our minds when we think of the court system generally. We think judges, black robes, prudence, dignity, a gavel that keeps things in order. And so just a brief word on that dignity. It has not always been thus in the history of Michigan courts. So this was from Silas Farmer's History of Detroit and Wayne County. One of the first sessions of the court, the court met at various houses. So there wasn't a court building. It met at various houses. According to the Detroit Gazette, the court sat sometimes at midday and sometimes at midnight, sometimes in the council house, sometimes at the clerk's office, sometimes at a tavern, and sometimes on a wood pile. That gives you some sense as to how the hearings were held. And let me borrow one more. This was from the same source, and talking. I'll quote the language for you because it's really quite charming. In September 1820, the court frequently held its sessions from 2 p.m. till 12, 1, and 3 o'clock in the morning next day, and cases were disposed of in the absence of both clients and counsel. During these night sittings, suppers of meat and bottles of whiskey were brought into court, and a noisy and merry banquet was partaken at the bar by some, while others were addressing the court in solemn argument, and others presented it to the judges on the bench, meat, bread, and whiskey, and inviting them to partake. This is not a scene that I'm used to seeing when I appear in court today. Although I have to say, it does sound a little bit more lively than the cases I've argued. To borrow from Twain, maybe we should draw a curtain of charity over that scene and let it stand for what it is. So that gives you some sense, though, of sort of the way in which the nascent court, but also, and I think we'll see this in the decisions, that doesn't mean that all the decisions were devoid of legitimacy, because as we go through legal analysis, you can see how the decisions were in some cases very carefully considered and thoughtful, and frankly, in many respects, as I said earlier, some that are of dubious moral legitimacy, especially in our eyes, but others that are frankly I'm quite proud of as speaking as a Michigander. So let's turn to it. Getting on the discussion of slavery for our first case. This is Dennison versus Catherine Tucker. Now, let's talk briefly about slavery. As I said, during the British and French rule in the Michigan area, slavery was an established legal custom. In 1792, the British census counted 179 slaves among 2,191 people living along the Detroit River. That's probably higher than Native Americans who wouldn't have been counted. Now, this is a key point. You'll recall I talked about the Northwest Ordinance, and that had guaranteed certain rights. Now, there was another legal principle that was at work here. This was a treaty that the United States had entered into with the British. It was Jay's Treaty. Some of you have probably heard of it. It was John Jay actually said that you could light the fires from, you could light your way from Washington to New York, I think is what it was, with the fires burning him in effigy at the time, because it was such a disliked treaty. He was thought to actually have completely given away the farm to the British. But I think in the fullness of history, it's generally regarded as been a really good deal for the Americans. In any case, it was negotiated in 1794. And one of the things that happened was that the British withdrew from Detroit and Michilimackinac in 1796. Now, the Northwest Ordinance that we talked about actually outlawed slavery in language that was to echo the 13th Amendment that came along down the road after the Civil War. It said that there shall be neither slavery nor involuntary servitude in said territory, meaning the Michigan territory, or in that case, actually the Northwest territory, other than in the punishment of crimes whereof the party shall have been duly convicted. However, even though that was the law, it didn't in emancipation. So this brings us to our first case, this Dennison versus Tucker case. In 1806, the Detroit attorney Elijah Brush, keep him in your mind, we'll talk about him in a minute. Detroit attorney Elijah Brush had leased two slaves, Peter and Hannah Dennison, from their owner, Catherine Tucker, on the condition that they'd be freed after 1 year. Now, Tucker actually had 4 of the Dennison's children as slaves as well: Elizabeth, James, and Peter. Tucker refused to release the children. So in 1807, attorney Elijah Brush obtained a writ of habeas corpus, requiring Tucker to appear and explain her decision. Habeas corpus is actually, it's a legal principle. It dates back a long time, well before the establishment of the American government. And it essentially is a vehicle, it's a mechanism whereby the lawfulness of his or her confinement. It literally means bring me the body. The idea is that the person detaining someone else has to come to court and demonstrate that the confinement of another person is lawful. It's used all time or often today in challenging and by prisoners who are challenging the lawfulness of their confinement in federal courts. Very common used back then by Brush to challenge the lawfulness of Tucker's confinement of the 4 children, Dennison's 4 children. Dennison had argued that given the anti-slavery provision in the Northwest Ordinance, that they should have been freed. Tucker responded and said, actually, no, the children had been owned since before the arrival of the Americans, before Detroit was surrendered to the British. And Tucker had claimed that the children were her property under the Jay Treaty and a Canadian ordinance which had governed under British rule. Now, remember our first note earlier, one of our judges is Judge Woodward, who gave his name to the famous road in the middle of Detroit. He actually authored this opinion. And he began with a forceful commendation of slavery. And he says here, and I'll quote it because I think it's very instructive. It helps frame some of the thinking that is happening in this time around the question of slavery. Judge Woodward says, in this territory, slavery is absolutely and peremptorily forbidden. Nothing can reflect higher honor on the American government than this interdiction. The slave trade is unquestionably the greatest of the enormities which have been perpetrated by the human race. The existence at this day of an absolute and unqualified slavery in the human species in the United States of America is universally and justly considered their greatest and deepest reproach. Legislatures, the whole body of their people, are advancing gradually towards its total extirpation. In the meantime, the interdiction of it in this territory ought to be considered as imposing a most serious and sacred duty. Calculating on its absolute non-existence, the laws have provided no special course of proceedings by which the question of the right of freedom is to be investigated. I hear that, and I hear a forceful moral condemnation of slavery as an institution. But then we come to what he had to do, or what he viewed as his duty in this case. Woodward ultimately said that he was not at liberty to return the children to the Dennisons. This is our first, what I would characterize as mixed result in terms of how we would view it looking back on it. Woodward concluded that because slavery had been allowed by the French until 1763 and continued by the British until 1796, Jay's Treaty protected the rights of British subjects, even though the Northwest Ordinance said that slavery was abolished here. That, in a sense, Woodward had to decide which one, the treaty or the Northwest Ordinance. And he concluded that Jay's Treaty prevailed over the conflicting ordinance. And the end result of that analysis was that certain slaves who were alive on May 31st of 1793 and in the possession of the British were held slaves for life. Those born after a certain date and under the establishment of the American government would have been slaves until a certain age and then freed. And none of the children of Dennisons were in these latter protected status. And so as a result, they were returned to Tucker. Now, Woodward noted at the end, and it was small consolation, I'm sure, to the Dennisons. Woodward noted at the end that his belief that this result, quote, brings the existence of slavery in the territory of Michigan to as early and as favorable a close as perhaps the imperfections necessarily attached to all human measures will allow to be expected. So in a sense, the court was saying incrementally, we are moving this in the right direction, even if it was an imperfect decision. Now,
And
oh,
Joe, sorry to interrupt real quick. If you can speak up a little bit, I got a couple messages that it's a little hard to hear you.
Oh, I'm sorry. Let me see if I can up my microphone here. Hang on a second. Is that better?
Yes, thank you.
Oh, okay, great. Sorry about that. If I can turn it a bit louder if needs be, so just let me know. So in any case, as a postscript, here actually is Elizabeth Dennison. Elizabeth and Scipio actually escaped to Canada, so they weren't returned. Ironically, even though the Canadian Ordinance had provided for their continued status as slaves, the Canadian government refused to return the escaped both Elizabeth and Scipio to the Americans. Now, Elizabeth actually eventually returned to Detroit in 1812, and she's currently buried in Elmwood Historical Cemetery, which is just down the road from downtown Detroit. You can actually go see her grave there, with a notation that she was the first Black female landowner in Michigan. So in that sense, at least for 2 of the 4 children, there was a slightly better result than we thought might have happened as a result of the opinion. Which brings us, though, to our next case, In re Richard Pattison. Now, this case was decided a month after the Dennison decision. Now, in that case, Pattison had sought a warrant to what he claimed was his lawful property, in this case, Jane and Joseph Quinn. Pattison was a wealthy merchant living in the Canadian town of Sandwich, and Jane and Joseph Quinn had escaped to Detroit and refused to return. Pattison argued that the laws of comity and nations warranted their return. Now, here's an important distinction. This is where the distinction of this case will turn. In the first case, the Dennison case, we saw that actually a treaty that had protected British citizens' rights couldn't be trumped by the Northwest Ordinance. Now, Woodward and the court is being asked to decide, okay, what about just basic principles of fairness between states and jurisdictions and countries? We respect the law of one state, so we should return what is claimed to be property from one state to another because you respect our laws. Essentially, the idea of comity is a legal principle that says you respect our laws, we'll respect your laws. It's not an absolute principle in the law. It's just something that courts will often grant other jurisdictions to ensure that there's some reasonable enforcement and balance in the legal systems. Woodward rejected all of this. He said the common law does not control property rights in human beings. The Northwest Ordinance prohibited slavery with certain exceptions. And though America would enforce the return of slaves from one part of the U.S. to another, they were not going to extend that to other countries. The court ultimately held that the idea that slaves would be required to be returned in all cases was improper. Absolutely not. We're not going to do that. And so this decision helped set the stage early on for Michigan's reputation as a safe haven for slaves, for runaway slaves in a sense. Now, I said make a note of the attorney, Elijah Brush. He had represented Dennison in the first case, in the challenge to Tucker's confinement. In this case, he represented Pattison, who was trying to reacquire the fugitive slaves. In the truest tradition of any attorney, he was perfectly capable of representing both sides of an issue at the right price, it appears. And so I saw that when I was reading this, and I was struck by the fact that Mr. Brush seemed to have willingness to take on virtually any case if given the opportunity. So this sort of summarized here, these two opinions illustrate really in contrast, the mixed legacy that slavery had in the context of Michigan Supreme Court. You could see within Woodward's language that he used in the Dennison case, his forceful condemnation of slavery as an institution, but that was contrasted with his belief that he had to be faithful to the law as he understood it. So it was questions of fidelity to the law and fidelity to a higher principle of morality. And when given the opportunity, when given the opportunity to go the other way in the Pattison case, he promptly took it. And so this is a problem, I will just note, that faces litigants and judges even today. Oftentimes, judges are called upon to make decisions and to rule on principles of law that they may disagree with, sometimes even disagree with morally. An easy example is there are hot debates even today around the question of abortion. And judges are called upon, despite their personal preferences, to apply the law as it currently exists. And this is an issue that, frankly, bedevils many jurists even today. To what extent are my own moral sensibilities limited by my obligations to the legal system in which I am an important part? So, speech over. Turning to the continued discussion here, though, I think the idea is that there is nuance in some of these decisions. Now, Michigan, as a result of some of these decisions, in particular the Pattinson decision, helped it acquire its reputation as a beacon of liberty on the lakes. So there was early cultural opposition to the institution, the political and legal institution of slavery. And so this actually helped contribute to migration, both from New England, from New York, and elsewhere. And both freed blacks and fugitive slaves over time migrated to Michigan, in part because of this reputation. Now, what's interesting is that it's not entirely and always well-deserved, as we'll see. It wasn't Michigan early in its statehood, early as a territory, was not a racial utopia. Even in some of its early laws, you began to see tension being created. Like, for example, one example is an 1827 law that was passed by the Territorial Council, where you started to see restrictions on Black residents. So you might have some protections as a Black resident, protections, say, for example, against kidnapping. But if you were a freed Black or a fugitive slave, you would have to register in the territory and provide a certificate indicating it actually would apply to freed only, your freed status, and even post a $500 bond to guarantee good behavior. So this demonstrates some of the tension that exists in the early territory. And though this particular requirement, I just would note, was controversial itself, even though it was passed by the Territorial Council. And there's actually, I don't believe there's any evidence that that bond requirement was actually enforced, but it was there on the books. In any case, notwithstanding that nuance, migration continued. Population migration from other areas, including by freed Blacks, would continue over the succeeding years. By 1830, there were 293 free Blacks in Michigan. By 1840, a census showed 707. By 1850, you got to 2,583. And by 1860, there were 6,799, all according to censuses at the time, mostly in the Detroit area and then Cass County in Southwest Michigan. Now, these migration changes presented challenges for the residents. The question that residents who were there and those who would come would be, okay, well, what does our legal system as it continues to evolve look like? What other rights would Blacks enjoy? And what did it even mean to be Black or white? And this is a thorny question, as we'll see. So it gets us to our next topic, which is voting and education, which is obviously once you're talking about free citizens, the question is okay, what is their right to participate in free government, and how do they become educated citizens to do that participation, to effect it and ensure that participation is well informed? And so the early statehood, by this time we're getting to Michigan statehood, there were debates over the rights of Blacks to vote and what those requirements would look like. So that takes us actually to our next case, which is Gordon versus Farrar. And it was decided in 1847. At the time, the Michigan Constitution had secured voting to, quote, white male citizens only. Now, Gordon had been denied the right to vote in Detroit. Gordon was partly of Saxon or English descent, and then partly of African descent. And so the court had to address the question on the meaning of whiteness and what happened. Actually, I shouldn't say that. The court had to address what would happen if a person had been denied the right to vote in these circumstances. Now, according to the court, this is language from the court, not mine, just so you're aware, quote, the Saxon blood greatly predominates over the African. He is of a complexion as white as or whiter than many persons descended from European nations. But there is a mixture of African blood in his composition. So So you can see even in the court's description the kinds of fights that were happening over these issues at the time. The question before the court was, could the election inspectors be sued for improperly denying Gordon the right to vote? And the court answered no, said it relied on the longstanding idea that amounts to a judicial decision, really, and this was believed to be a judicial decision by the election inspectors, that they couldn't be subject to a civil lawsuit. Now, the court never really questioned the requirement that the voter be white and what that really meant at the time, but the decision had the effect of insulating any challenge of an effort to expand the right to vote. If someone was denied the right to vote, they couldn't sue the person who had wrongfully denied them that right. And that was, again, one of those decisions we would look at today and go, okay, this was one that was diminishing in the rights of Blacks at the time. And then we get to a related case issued about 20 years later. This was one where it was issued just after the Civil War had ended. Now, William Dean was charged with illegal voting. And the court had to address, in this case, the court had to address what the Constitution meant when it said voting was limited to white male citizens. Now, the court noted that at the adoption of the Constitution, a provision had allowed for, quote, and this is again language of the time, for, quote, every colored male inhabitant to vote as well. But that provision had been rejected by the voters. And so the court was asked then, with that context, to determine the meaning of white as understood by the voters when they adopted that Constitution. And so even though the Civil War had intervened, the court found itself bound by the Constitution. And some very, I think, instructive language here that I'll quote for you. The court says, the reasons for drawing distinctions in this country between different classes of inhabitants are notorious. And while the course of events, meaning the Civil War, has, with the destruction of slavery, very considerably modified public opinion upon questions which bore upon the people formerly enslaved and their kindred, we cannot regard provisions made under the old state of things as at all changed in their meaning by any subsequent events. So in other words, the court is saying in this case, it felt itself compelled to continue to analyze the law as it was passed, when it was passed, without considering the impact of intervening events. Now, what's interesting about that, side note, that is not an idea that was universally adopted. In fact, many other courts considered the adoption of what are called the Civil War amendments to the United States Constitution as having meaning and an interpretive bearing on the earlier amendments. So essentially, the earlier amendments, the first 10, the one we're all familiar with, the right to free expression, the freedom of right to bear arms, and so on and so forth, those amendments, their meaning was subsequently by many courts viewed through the lens of the Civil War amendments. Now, in this case, in People versus Dean, the Michigan Supreme Court did not adopt that principle and instead just said, well, we have to consider the meaning of the original language as passed by the voters. And so the court ultimately rejected the attempt to reinterpret the older law by the happenstance or the challenge or the circumstance of intervening events. So the court then said, and this is the key language, we cannot truly interpret the language of our Constitution upon the subject of voting without giving due consideration to the fact that it sprang from the existence of an extensive and remarkable prejudice, which has been recognized in all countries as one of the peculiar features of American society. But to go beyond this, from many motives of benevolence or supposed public policy, would be to create and not to construe the law. And that's what the court, you could see in the language there as it's discussing its opinion. The court ultimately believes that it is bound by the law, even if it doesn't like it. Now, what's interesting here is that there was a forceful dissent. And this is one of those push and pull things that we see within the law as it evolves. A dissent, by the way, is when the court, let's say there's a court of 7 judges, or in this case, I think at the time it would have been 4. The majority will form the opinion of the court, and whatever the majority rules in that case, that is the court's decision. Now, if somebody disagrees, and sometimes they disagree forcefully, it's called the dissent. So it's essentially saying, nope, I don't agree with you all, I disagree, and here's why. So in this case, Justice Martin dissented, and his dissent, I think, is noteworthy because of it highlights 2 things that are at work here. Number one, it highlights the different passions that were at play even then and in resolving these issues and these tensions, but it also illustrates some of the legal principles at work in the court's analysis. So Justice Martin thought the entire thing was absurd, that Dean should be prosecuted for attempting to vote here. It made absolutely no sense. Apparently, the prosecution had called a doctor at trial to give an opinion on the percent of African blood in Dean's body. I mean, obviously, to our view, completely absurd, but frankly, it was also to Martin's view, very absurd. And this language here I thought was extremely interesting, where Justice Martin says, quote, "I need hardly refer to the facts of this case to show the absurdity of any other rule or of the attempt by judicial action to fix an artificial line of demarcation between black and white. The very necessity of calling in Dr. Pitcher and having an examination of Dean's nose to ascertain whether he had black blood in his veins and thereby determine his right to a vote affords a sufficient commentary upon the rule my brethren have established. If this is the correct rule, we'd better have the Constitution amended with all speed so as to authorize the election or appointment of nose pullers or nose inspectors to attend the election polls in every township and ward of the state to prevent illegal voting." So you can hear the anger coming through with Justice Martin and how he thought what the court was doing was absolutely absurd and unjust. He wasn't able to stop it because he didn't have command of majority, but you can hear in his voice the frustration that's coming through. And I think you'll see as we work through these opinions how the court continues to evolve in this push and pull process. So, keeping on our theme of migration and the intersection of peoples, we're turning to education. Now in this, I'd like to highlight what in my view is one of the jewels of Michigan's jurisprudence. It's the Workman versus Board of Education case. It is a case that I think you'll see at the end of it. It's one that you can be proud of as a Michigander. It was decided. So it was decided in 1869. Workman had applied for his child to go to the Detroit school. Now his child was, and again, this is the language of the time, according to the court's opinion, a quote, mulatto, essentially meaning he was both black and white. Now he had been refused entrance because of this. There was room in the system. That was undisputed. Workman was a resident of Detroit. He owned property there. He paid taxes there. He even paid taxes to support the schools. Now, they had separate schools for black children. I'm sure many of you are familiar with this concept that evolved in American law called separate but equal. It came down in a famous case called Plessy versus Ferguson from the United States Supreme Court, which said we didn't have to have integrated schools. You could have separate facilities for black children and white children, and as long as they were equal, it was considered okay. So Detroit had actually, and by the way, this decision, Workman versus Board, was decided before Plessy, and we'll get to that in a minute. But in this case, Detroit had set up schools for specifically African-American children, and it required African-American children to travel there, regardless of location, to those schools, which did not even have higher level grades. So the question before the court was whether or not the Detroit Board of Education had the authority to do this under its general laws. Now, Michigan was actually a leader in black education at the time. The percentage of black children attending school in Michigan in 1860 was 40%, far exceeding the 35% average of free states around the country. The legislature had actually passed in 1867 that stated that, quote, all residents of any district shall have an equal right to attend any school therein, provided that this shall not prevent the grading of schools according to the intellectual progress of the pupils, or be taught in separate places where deemed expedient. So the Workman versus Board of Education case came before the court, and Justice Cooley was its author. Now, Justice Cooley is generally considered Michigan's greatest jurist. He was brilliant constitutionally. He made significant contributions to the law and constitutional interpretation. He wrote a treatise on law. He's just a great jurist all around in terms of the quality of his legal mind. And he rejected the Board of Education's argument outright. He said, "It cannot seriously be urged that with this law enforced," meaning the law the legislature had said that all residents of any district shall have an equal right to attend any school therein. "It cannot seriously be urged that with this provision enforced, the school board of any district which is subject to it may make regulations which would exclude any resident of the district from any of its schools because of race or color or religious belief or personal peculiarities. It is too plain for argument that an equal right to all the schools, irrespective of all such distractions, was meant to be established." Here's the key point. Justice Cooley held that this was the case, that the Board of Education couldn't do what it did, and it found in favor of Workman. But the key point here was that this was based in the law. It was based in Michigan law. Cooley actually had to interpret both the law and the Michigan Constitution. Now, let me step back. There's a principle in the legal world that says essentially that a judge should decide a case on the narrowest grounds possible. And so the reason for that is because judges aren't supposed to make law. And so they should decide the case that's before them and not go sort of haphazardly talking about other principles of law that they don't need to talk about. And that principle was at work in this case, where Justice Cooley said, because he found the statute at issue to be applicable, he said it didn't become important to consider what would otherwise have been the law. So essentially what he was doing was he was giving a nod to the idea that there's a law here that governs and says that these kids can go to the school. But if there wasn't, I would seriously consider whether or not the Constitution required it anyway. Because if you'll remember, I'm sure you all remember, the Constitution of any jurisdiction is its highest authority, and the laws that are made under it have to be compliant with the Constitution. And if they're not, they get overruled by the Constitution. So Justice Cooley was saying, look, I would have serious constitutional problems with this, but the law is in place, and so it protects it, and this is what the law is. That's not to say that segregation didn't continue in Michigan. It did, but it was not a legal segregation. It wasn't enforced at the point of a law, and that was the key. So under Michigan law, students were not going to be kept separate. And this decision was nearly 3 decades before the Plessy versus Ferguson case that said separate but equal was okay. And it was 85 years before the Brown versus Board of Education case, which said separate but equal was not equal. That was the United States Supreme Court case that rejected separate but equal and said integration of the schools was constitutionally required. So while Workman was not a perfect decision in the sense that it wasn't grounded in the Constitution, it was a compelling one and frankly progressive for its day. So as a Michigander who's a student of history, it's one that as I said, I think it's one of the jewels of Michigan jurisprudence. So continuing on our theme of the migration and the intersection of peoples, what other rights do free peoples expect? So when free Blacks came to Michigan, what should they expect in terms of rights other than voting and education? The next obvious one is public accommodations. You've all seen, I'm sure, footage of lunch counter sit-ins, equal rights of access to people being denied, protesting on the refusal of businesses and other institutions to grant equal rights and access to the same restaurants, lunch counters, drinking fountains, bathrooms, all those things. Well, Michigan was not insulated from all those fights. In Michigan, it regularly happened that Blacks were denied service at hotels, restaurants, theaters, churches, common carriers, except in sometimes segregated and substandard areas. Some of those Blacks resisted and they fought back. And we have 3 cases to talk about specific to those fights. The first one is Day versus Owen. It was the first, actually, sorry, here we go. It was the first public accommodations case in Michigan. A Black abolitionist, William Howard Day, and his wife, Lucy, had been denied cabin accommodations on the steamer Arrow on its route from Detroit to Toledo. And they were offered accommodations instead on deck. They sued. They sued John Owen, the owner, for violating the state law on common carriers. Ships, buses, taxis, common carriers, trains, et cetera, et cetera. The funds for that lawsuit were actually raised by Blacks in Detroit, as well as a wealthy New York abolitionist by the name of Garrett Smith. Now, the court ruled, again, in one of those decisions that one side or the other, that the Days had a right to be carried not on a particular accommodation, but just to be carried generally. That is what the law provided, essentially saying, we don't have to give you the nicest facilities. We just have to give you facilities. As the particular accommodations being carried, the court allowed the boat owner to restrict it by rule, because the boat owner had argued that it was better for his passengers to have segregated areas, and the court allowed him to do that. Now, that meant that the court upheld segregation as a policy aboard private properties that were offered to the public. So this decision actually was one of those that went the other way and helped undermine Michigan's growing image as a beacon of liberty. But then we get to Ferguson versus Gee. As history tends to do, it moves and fits and starts. And so in 1885, our legislature adopted the Civil Rights Act, guaranteed full and equal privileges of inns, restaurants, eating houses, barbershops, public conveyances, theaters, without regard to race. This was in 1885. And so Ferguson versus Gee, it's a powerful decision. It was an 1890 case. Gee had managed a restaurant in Detroit. And though the law had moved, the culture hadn't changed, at least not fully. And it's kind of illustrated what happened here. In this particular establishment that was managed by Gee, there was a restaurant side and a saloon side. And so the Ferguson had gone in to try and go to dine with his wife, and his friend. And in that case, he had testified that he and his friend sat down on the restaurant side at the first table, and they asked for lunch. And the waiter said, "I can't wait on you." And Ferguson responded, "What do you mean?" The waiter replied, "We cannot serve you kind of people here. It's against the rules of the house to serve colored people in the restaurant. If you want anything to eat, you're going to have to go to the other side of the house." After waiting a few minutes, Mr. Ferguson went to the office and said to Mr. Gee, "Mr. Gee, I came to your restaurant as a friend, and I've been insulted by one of your waiters," and I told him what the waiter had said. And Gee replied, "That's all right. It's the rules of this house, and if you want anything to eat, you're going to have to eat on the saloon side." And so Gee later claimed at trial that he had actually offered Ferguson a table tucked away in one corner of the restaurant side of the same room, with a tablecloth and kind of nicer. And it was just out of the way and out of the eyesight of the white patrons. The jury had actually found in favor of Gee. So it tells you what the makeup of the jury was. It was, essentially, this is that push and pull between the culture and what the law was. But the court said that finding was based on an error in instruction by the lower court judge. Now, this is an important point. Juries, when they sit in decisions, are what is called finders of fact. That basically means they have to make decisions about what the facts of a particular case are. The judge tells them what the law is. Well, in this case, the Supreme Court said that the judge had screwed up telling the jury what the law was. And here's the key language from the court. Remember, the new law had been passed in 1885. It was a civil rights law guaranteeing accommodations. And the court said, "This statute exemplifies the changed feeling of our people towards the African race and places the colored man upon a perfect equality with all others before the law in this state. Under it, no line can be drawn in the streets, public parks, or public buildings upon one side of which the black man must stop and stay, while the white man may enjoy the other side, or both, at his will and pleasure. Nor can such a line of separation be drawn in any of the public places or conveyances mentioned in this act." This was a powerful statement by the court of enforcing equal rights within the non-legal systems, the public accommodations of the day. And this is, I think, an important case insofar as it makes a very clear statement. But I'd encourage you to go back and read it, because you can even see in the language of the opinion how the decision and the attitudes of the day are not as what we would characterize as progressive, as treating with the blacks of the day with equal dignity. And here's what I mean. There's language in here that I think it's historical, has historical utility, even though it does have some insensitivity to our modern ears. And so I highlight it for your consideration, because I think it helps give full context for what was going on in some of these decisions. And the court says, because it was divinely ordained that the skin of one man should not be as white as that of another, furnishes no more reason that he should have less rights and privileges under the law than if he had been born white. And that I had no quibble with. And then the court continues. The law, as I understand it, will never permit a color of misfortune that God has fastened upon a man from his birth to be punished by the law unless that misfortune leads to some contagion or criminal act. Nor while he is sane and honest can he have less privileges than his more fortunate brothers. The law is tender rather than harsh toward all infirmity. And if to be born black is a misfortune, then the law should lessen rather than increase the burden of the black man's life. So you can see and hear even there, it's almost belittling in the way the court, or it is belittling in the way the court characterizes it. We would look at a decision like that and say that even that his history is pushing forward, at least I look at it and I hear it, even as history is pushing forward and finding ways to accommodate and provide equal protection of the law, you can still hear the prejudice that exists in the day and in the choice of the words used by the author. I would read that and think it diminishes his dignity to style it that way. And this is just our way of sort of understanding how history develops. I think it's a useful way of seeing how history develops and fits and starts. Now, what's particularly compelling about that piece is that, let me get here real quick. Here is William Howard Day. And then you've got Ferguson versus Gee. I'm sorry, I should have been skipping. Here we go. William Ferguson. He was a prominent Detroit business owner, became a lawyer in 1897. He was the first African-American elected to the Michigan legislature. So you can see here in this, just these 3 bullet points in the slide, it stands in contrast to the language the court was using in this case. And it struck me as particularly a compelling case for that reason, and an interesting subject for the study of history to see how the court's legacy is in some respects mixed. It's with the one hand pushing forward and doing things in a way that guarantees rights, but it's also doing so in a way that to our modern ear, at least to my modern ear, feels belittling. So getting to our last slide here. Bolden versus Grand Rapids Operating Corporation. Emmett Bolden was a dentist by training. He sought to purchase a ticket from a theater in Grand Rapids, my hometown. He wanted a ticket on the first floor and was refused because he was black. So he sued. The theater owner challenged the constitutionality of that civil rights law we had talked about, said it was unconstitutional, and the court disagreed. The court dismissed his case, rejected his argument, and then affirmatively said that blacks had the right to sue for the denial of accommodations. So this goes back, you'll recall, we had that earlier decision that said blacks couldn't sue if they were denied the right to vote. This decision comes around full circle and says, no, if you're denied accommodations, if you're denied things like that, you absolutely have the right to sue under our laws. And Bolden was granted the right to sue for infringement of his liberties. So that's, again, sort of moving the court forward in those fits and starts in a positive way, in my judgment, a positive way. And here you have Emmett Bolden. He was actually, as I said, he was a dentist by training, and he was obviously an activist as well, and had a significant impact on Michigan law. The final topic, before I lay it open for questions, I'll try to be brief, is the question of restrictive covenants. And this is a fairly lengthy history in this country of building into property ownership limitations on who can move in, who can live nearby. It's part of our history that we have to reckon with. Redlining of properties occurred throughout history, 1920s, 1930s. Lenders would refuse loans around certain neighborhoods on the theory that if they were lending money to blacks, the lenders were worried they weren't going to get paid back, and so they refused to do so. And that had very substantial negative effects on the ability of black citizens to get loans, to sort of build wealth in the same way that their white counterparts were doing. And the racially restrictive covenants were also a tool that was used as part of that effort. It was essentially, they were, I should back up. When I say restrictive covenants, what I mean is that buyers and sellers of property, whether it's homes, whether it's businesses, can have language or would have language put in their deeds saying that blacks had to be kept out of particular areas. The thinking was that they wanted to, keep neighborhoods or areas of particular counties and cities all white. And so, two final cases highlight both of these or this issue. Parmalee was a 1922 case, and what had happened was when originally platted, the Ferry Farm had lots that were sold subject to a condition that said no building shall be built within 20 feet of the front lot line and shall not be occupied by a colored person. And Charles Morris and Anna Morris sought to buy in that subdivision, and Parmalee sued to stop it. Morris, who was black, challenged the restrictions under the 13th and 14th Amendments, saying that they were unconstitutional. The Michigan Supreme Court rejected that argument and said the 14th Amendment only applied to actions of states, not individuals, and actually cited the Plessy versus Ferguson case, which I'd mentioned earlier, saying separate but equal was okay. So the question was Michigan public policy going to be, was it going to reject this effort to include restrictive covenants in deeds that make them enforceable? And the clear answer by the court was no. And the court essentially said this deed was public record. It was available for anyone to go look and see what it said. You, Morrises, chose to seek to buy. You should not have bought it unless you observed the restrictions that were contained in it. So the court unfortunately upheld restrictive covenants in the Parmalee case. Fast forward 25 years later, this issue again came before the Michigan Supreme Court. And again, it was concerning a racially restrictive covenant, this time that was in the city of Detroit. Orsel and Minnie McGee had purchased property there as blacks, and then Ben and Anna Seeps sought to exclude them and enforce the covenant. And so the McGees asked the court to overrule the decision in Parmalee. And the court again said, no, we're not going to overrule Parmalee. We think that the 14th Amendment only restricts state action, not federal action. And so again, the Michigan Supreme Court said racially restrictive covenants were enforceable. However, the case went to the United States Supreme Court. And so in a happy twist, the Supreme Court took up the issue and said, no. When you have a private agreement that racially restricts individuals from property, that agreement may or may not be enforceable. I'm sorry, may or may not be constitutional, but the enforcement of it by a court is unconstitutional. So essentially, the court said, look, when the court takes actions to enforce a private agreement that would violate the Constitution, that itself is an unconstitutional action. And so from that day forward, racially restricted covenants were considered unconstitutional and stopped being enforced. So you can put them in your agreements if you like, but the courts aren't going to force them, and they're not as good as the paper they're printed on. I hope that what you get out of all of this is that our history is imperfect. It's an iterative process. It proceeds in fits and starts. Our Supreme Court contains, its history contains both decisions of virtue and decisions to be rejected. And it's that process that our Constitution calls forming a more perfect union, which is what really the goal is through that development of the law. I get to this last question, reason for optimism. And I say that because there is a particular anecdote that I'd just like to share with you. And I'd like to close with something that was actually uncovered fairly recently. It was the attorney who had argued the Ferguson versus Gee case was a gentleman by the name of Augustus Straker. Now, Detroit Mayor Dennis Archer, not too long ago, opened up a time capsule from 1900, in which Straker was the only contributing African American. And he put a letter in there. I think I may even have a picture of Straker right here. Yep, there he is. And his letter in that time capsule was, I think, very compelling, and I wanted to share it with you. And he said, this was from 1900, Sir, none who have lived the allotted time of human life within the confines of our beautiful city, namely Detroit, can fail to notice the changes and events which have marked the 19th century, and especially so as relates to the colored people living and who have lived in Detroit. The 19th century found the colored people of Detroit a race of slaves, although slavery is not known ever to have had a foothold here. The incoming 20th century finds every man and woman and child of the colored race enjoying complete freedom under the law. The 19th century found the colored race in Detroit ignorant, uneducated, poor, and unenlightened, save with a few exceptions. As the 20th century draws upon us, with every school door in the city of Detroit wide open, welcoming within its walls every colored as well as white child, the 20th century finds the colored citizens of Detroit in the enjoyment and right to go and enter every public place established for public accommodation. If we should augur from the past and present, we have the brightest expectation for the future. A prejudice does now exist on the fringe of the 20th century. I predict that the sunlight of a more perfect understanding of the fatherhood of God and the brotherhood of man will drive out the demon prejudice, and when the 21st century arrives, he will find no resting place in the beautiful city of the Straits. Now, perhaps Straker was a bit optimistic. Prejudice has not been fully eradicated, but our history, I think, does give us reason for optimism. It reminds us, in the words of Dr. King, that the arc of the moral universe is long, but it bends toward justice. And I think the history of our Michigan Supreme Court shows that it ultimately is bending in that direction. So that's it for me, but I am more than happy to take questions. Let me see if I can stop sharing here.
Yeah. I did get a couple questions regarding the Gordon and Dean cases. What evidence was presented to prove that people were of African descent or that they had African blood?
Right.
Like on the opposite end, right? How did that work?
Let me see if I can. Let me go ahead and go back to make sure I've got this here. 1 second. I've got my. So we're specifically talking about the two voting rights cases, right? So
right. I think that's the Gordon and the Dean. I didn't write down the other names involved.
Right. So I can tell you that the Gordon case, that was the case. I think it was the question of whether or not he could actually sue to challenge the unlawful denial of his right to vote, or whether or not he could legitimately challenge that. The only evidence in the court's opinion, and I guess I should start off by saying, when you get to the Supreme Court, what has happened before that point is the development of a record. Okay, and so there may be a jury trial where the jury is presented with all sorts of evidence, and the Supreme Court might only consider a small portion of that in its review, because the court is not, generally speaking, concerned with looking at every little nook and cranny of evidentiary issues. The Supreme Court is more concerned with broader legal questions. And so it's not, we sort of have limited evidence about what evidence was actually before the court in any given case. All I can tell you in the Gordon case was that, according to the court's opinion, there was language in the opinion that said that the Saxon blood had greatly predominated over the African blood. I don't recall specifically if the opinion detailed how that evidence came in, because it wasn't really critical to the court's disposition. The court was more concerned in that case with really whether or not you could sue to challenge the unlawful detention. So I don't know that we have a clear record just from the opinion. Now it's possible, and I'll confess I haven't done the digging to go back and see if we actually have a record of the trial, because the trial, if we do have a historical record of the trial, then you would have more evidence of that. Now, contrast that with the People versus Dean case. That's where they called the physician to basically give an opinion as to how much what percentage of African blood Dean was thought to have. And so his opinion, and this is again, you get to glean it from Justice Martin's dissent, because what he gives you in his dissent is that this Dr. Pitcher had examined Dean's nose, and he concluded that because of the length and breadth of his nose, he must have had a certain percentage of African blood that would have gotten him past the threshold. But this is what we would call in the law junk science, right? I mean, there's really no medical basis for any of this. This is just them trying to justify a position. That's how I would characterize it.
Thank you. And can you remind us of the years that those cases happened?
Yeah, sure. Let's see here. So Dean was 1866. This is 1 year after the Civil War had ended. So you got to, in the context, right? This is very much on everyone's mind. What do we, this whole thing has happened, and now we have to begin to piece together the consequences of it. And whereas the earlier case, the Gordon case, was in 1847, so that would have been 20 years earlier.
So one was pre-war and one was
Correct. Correct. Even though they ultimately both kind of landed in the same general direction, the war was front and center in the Dean case in a way that obviously it wouldn't have been for Gordon.
Yeah. And then in the fits and starts of history, where do you view us along the historical timeline compared to what we fought for in the past?
It's interesting. That's a really great question. I would say that we have one of the reasons I like history is because I think it really gives you perspective, right? I mean, it really helps you see what are we the inheritors of. I have at times I've got 3 kids, and I as a lawyer, right? You sit and you talk to them about the good and the bad, and it's easy for us. It's like there's a tendency to reflect on our history and think, oh, we have so far to go, and that's true. I do think there are things that we have to continue to improve upon. But when you look at the fullness of history, I mean, slavery is a great example. Slavery was part of so much of the human condition throughout its history. I think we should be proud as a society that our people that are our forebears fought to end it, and it did end, and that's something we should celebrate, even if we haven't completed that journey. I mean, what did Lincoln say? That maybe that 400 years of unrecorded toil, must, and every drop of blood drawn to the last should be paid with another drawn by the sword. It may be that the fact that history was so long in this country, slavery was so long in this country before the Civil War finally ended it, that it may just take enough time for the consequences of that institution to be fully rooted out. But I think we are heading in the right direction. And I think seeing that history, we're obviously not there, but I think we are even substantially better than we were when it was Augustus, what's his last name? Augustus Straker was talking at the end of the 19th century. So that would be my answer to that question. There's no, as a lawyer, right? I mean, it's kind of like when Eisenhower said, "Give me a one-handed economist," because I'm sick of saying all economists saying, "Well, on the other hand." I mean, that's kind of what lawyers do. We just we do this. But I do think, as a general rule, I like the fact that we are in fitting and starts. We keep pushing ourselves in the right direction.
If someone wanted to, as you suggested, read the Ferguson versus Gies or any of these other cases, where would we go to read them?
Sure. Well, I mean, the easiest source is Google. Frankly, a lot of this stuff is just available online. Most older cases like this are just publicly available. If you search, I think you might even just be able to search on the name. So
Okay.
Let me just see if I can do a quick
Sure.
Ferguson versus. Let's see here. Yeah, I think Google has done a pretty good job scanning most of this stuff. Um, and it looks to me like a lot of this is available just if you just run some searches. The way law works is cases actually have um, specific citations. And so, like, for example, Michigan has what's called a reporter. And the way it works is for every volume of reports each year the court issues, it'll have a number. So first number is the volume, the latter number goes like 890 Mich 430. The first number tells you what volume of Michigan reports it is. The last number tells you what page in the volume that it shows up in. And so if you just search according to those numbers, if you type the names in, you'll see the numbers, and that'll help you narrow your search.
Wonderful, thank you. I have a comment, not a question, but a comment. We must argue against the notion that nothing's changed, while at the same time being honest about what hasn't. Agreed. That is all that I have in my comments. But
Can I
yes,
just
Ms.
ask
Cheryl.
one thing? And that is, would you tell us, Mr. Gavin, just a tiny bit about what the Historical Society of the Supreme Court is? Because I had never heard of it before, and I don't know what you offer the public beyond what we've heard, which is wonderful. So I appreciate it.
Thank you. Thank you. In fact, my executive director would not be pleased with me that I'm not doing a good job on that very subject. So I appreciate that. Let me get to the end here and actually, oops, I'll show you. That's my little bio, but here. So there's our executive director for anyone who wants to contact Lynn. But you can find us on michigancourthistory.org. And we essentially that I would characterize our activities as the preservation and dissemination of information related to the court's history. So we publish newsletters that are of topics relevant to the court's history. We have actually education materials for teachers that want to incorporate things in their education lesson plans. We have just historical vignettes available online. We have annual, we'll do like presentations, like things like this, obviously, but we'll also do just different things around the state from time to time. We'll have presentations. We'll have, luncheons where we have folks come speak about historical topics of relevance. And we also, we are also actually the curators of the portrait collection. So if you're ever interested in seeing some of the court's history sort of in person, you can go to the Michigan Hall of Justice and you can wander around. It's publicly open. The security guards, I think they usually ask why you're there, so you may want to check in advance, to see if the court has open days. But it's a public institution. You're allowed to go there. You're allowed to observe court. You can be a visitor, and you can actually see the portraits that are around. We have portraits of virtually every justice that has sat on the court, and they're placed in different spots around the building and elsewhere. Really, and we also have exhibits that kind of showcase little things about the court's history. So we're really all about preserving history and disseminating it in a way that is accessible to people.
May I just ask why it was started in the first place?
Great question. It was started actually by one of the court's justices, Dorothy Comstock Riley, and she was, by all accounts, a force of nature, and wanted to make sure that there was something preserving the institution of the court other than just the court itself. That was the guardian of the court's really artifacts and memorabilia. So as a simple example, many of you are probably familiar with the film Anatomy of a Murder. And that was actually a book that was authored by one of the former justices of the Supreme Court. He penned under the pen name Volker. No, I always get backwards. Trainer, Justice Volker. There we go. And so anyway, he was a big fly fisherman. He was from the UP. Great, interesting character. But among other things, whenever he would write a note to a colleague or something, he would include a little leaf from his either his garden or his lawn, just as kind of a, hey, this was part of just his character. And so we acquired just little things like that. Like I think we even have like one or two of those as part of notes that he sent. So just little interesting historical little features that kind of give life to the court as an institution, more than just something that decides cases, but really is staffed with people who are sort of charged with making sure that the laws of this state are properly administered.
Thanks. Thank you.
And I don't know, Jennifer, if we have time to open it up for maybe other comments or questions, if people want to ask.
We can
questions.
do a little bit, but the library needs to close at 8.
I think I ran long. I'm sorry, Jennifer. I was talking.
No, it was wonderful. So I'm not complaining about your running long.
Okay.
And I will point out that I knew of the existence of the society because Joe presented at the Detroit Historical Society, and I received that notice. And so that was why I knew the society existed.
Oh. I see one comment here that I'll just mention. I think is spot on. The comment here is, it seems that interpretation of the law is a very human exercise. I think that is exactly right.
Yes.
You know, it is a human institution. We all think of the law as sort of being immutable, but the reality is it requires people of good conscience and goodwill to implement it, and that's what our society depends on.
Yes, well, do we have more questions? We have a few more minutes.
You can put your hand up and we can unmute you.
It should be under more, being able to raise your hand. They keep changing things.
Yeah, there's a react button on the bottom of the screen.
Well,
I
when
see.
is our next, do we have a confirmation on?
Yes, we do. I wanted to point out that this recording will be on the YouTube channel for the League of Women Voters program at the library. Usually within about a week now, we have someone who's more prompt in getting this done. But, here we go. I try to have these windows open and ready. So this is the link on Eventbrite for registering for our next program. And it is on the census and how congressional seats are allocated, and just why it is that Michigan keeps gaining at least a few people, but keeps losing congressional seats. So that is our March 11th program, same Tuesday, second Tuesday of the month. And if you have anything that you'd like us to deal with in the future, please let me know. I'm happy to, we're happy to look into suggestions. And we will probably bug Joe again to talk about some other topics related to the Supreme Court, the state Supreme Court.
I'm more than happy to do it. This is in my day job, I'm a healthcare litigator, so it's kind of fun to have a little history, and kind of talk about that stuff.
Yes. Okay, thank you. Do we have any more questions?
I have one just very short question. What was the first Black or African American judge in the Michigan court?
I'm sorry?
Court? Do you know? Who was the first Black or African American judge in Michigan Supreme Court? Do you know off the top of your head?
I'm embarrassed to say I don't know the answer to that. Let me just see if I can figure that out. And we may know offhand. I'm hoping this isn't recorded, because my executive director will kick my butt for not knowing the answer to that.
I can ask that the recording be stopped here. I mean, that the recording that is posted be stopped here.
Let me see if I can answer that question for you, and just real quick, because I think we might even have that on our website. We got the biographies of our justices. Ruth, I'll have to get back to you on that. I will find out, though, because now I'm going to need this for this presentation.
You are.
Yes.
Absolutely. Good question. I hope that part doesn't get published.
I will ask. that
Thank
it
you.
not be posted. Thank you again, Joe, very much. Thank you to Cheryl and to Ruth, who are other members of the committee, making sure that we somehow get these events organized. Thank you for
very
joining us,
much. Thanks
and
for
I
having
hope
me.
to see you again in the future.
Thank you.
Yeah.
Bye-bye.
Thank you.